Tako, sedaj pa prihajamo na čisto vsebinski del in kot prvo bomo imeli našega glavnega slavnostnega govornika, profesor dr. Jožeta Štravsa. Mogoče ga mlajše generacije ne poznajo tako, ampak profesor dr. Jože Štravs je svetovno znani pravnik na področju intelektualne lastnine. Ponosni smo lahko, profesor Štravs, da ste z nami. Ponosni smo lahko, da ste slovenskih korenin in da ste tako pomembno oblikovali področje intelektualne lastnine številna leta, ne samo v evropskem prostoru, ampak tudi na svetovni ravni. Vaša, mislim, da najbolj omembe vredna funkcija, kajti bile so številne, zato jih ne bomo omenjali, je seveda to, da ste bili dolgo let direktor Max Planckovega inštituta v Münchnu, gostujoči profesor na številnih univerzah po svetu, ste tudi dopisni član Slovenske akademije znanosti in umetnosti, strokovni svetovalec ste bili pri številnih mednarodnih organizacijah, od OECD, UNIDO, Svetovne banke, Evropske komisije, Evropskega parlamenta in drugih, in ste nosilec številnih odlikovanj. Kako?
Ja, hvala lepa za prijazne.
Izvolite, tako, saj sem ravno želela končati, torej prav veseli smo, da ste z nami in se veselimo vašega širokega pogleda na temo, ki smo si jo nekako izbrali za uvodni, ta častni za slavnostnega govornika, kakšni so aktualni izzivi za pravo in pravnike, posebej, kar se tiče torej tega slovenske smeri, če lahko tako rečem. Izvolite, cenjeni profesor.
Ja, hvala lepa, profesor Trstenjakova, za te preveč spodbudne in lepe besede. Veseli me, da sem po mnogih letih spet enkrat udeležen ene konference Slovenskega svetovnega kongresa kot aktivno sodelujoč. Moram priznati naprej že, da nisem strokovnjak, pravni strokovnjak evropskega prava in da je bil za mene tudi tematika izziv kot tak. Moram tudi dodati, da evropski in slovenski pogled, kar se slovenski pogled tiče, je bolj moj osebni pogled in bolj pogled ene države članice, kot je na primer Slovenija, lahko pa bi bila tudi kakšna druga. Naprej se moram že opravičiti in upam, da mi boste to res oprostili, da ne bom govoril v svojem materinem jeziku, nego v angleščini, temveč v angleščini iz enega razloga. Slovenija je po mojem mnenju ena tistih malo katerih držav, ki res zelo, zelo v detajlu uporablja slovenske izraze, ne glede na to, za kaj gre, celo če gre za Dallas Mavericks, govorijo o Dallas teličkih. Tako da bom jaz, če mi dovolite, to prezentacijo imel v slovenščini. Ker je dr. Pleskovič omenil mene, moram tudi jaz reči, da me zelo veseli, da ga po tolikih letih vidim in nisem pozabil, da mu še dolgujem eno kosilo, ki sem ga imel z njim v Svetovni banki pred, ne vem, morda 15 leti ali pa približno pred toliko časa. Torej, dovolite mi, da zdaj preidem na angleščino. Profesor Trstenjakova, upam, da mi boste to nekako oprostili.
Seveda, seveda.
So, I will be trying to be as brief as possible. I know that I have 30 minutes. I should not start and losing time with too much of introductory remarks. Now, I will be trying to touch upon the notion of the law and the legal order of the view in general, spend more time to talk about the Court of Justice of the European Union as a guardian of the effectiveness and primacy of the EU law, then switch to the current challenges. Those who had the opportunity to have a look at my abstract, they know what is meant by that, and finish with some thoughts about the challenges for the lawyers and how the lawyers and the politicians may act together to solve a number of problems. Now, thinking about the notion of law, this is more an issue for legal philosophers than for somebody who has spent his life more or less dealing with issues in the area of intellectual property. But I found that Duncan Kennedy, who is a legal philosopher at Harvard, now emeritus, that he some years ago made the point about the obscure relationship between politics and law. Is really politics law with other means? He stated it seems that to be true, because in the sense that politics flows as much as from the unmeetable, that is the emphasis, unmeetable demand for ethical rationality in the world, as from the economic interests or pure Paulust. He used Lust, the German expression, with which it is so often discursively associated. If one takes this seriously, then it means, of course, that politics, the law, the politics in the means of law, is more or less always, especially if it is a law of an association like, a building like the Union, that it is a result of a compromise. Our colleague, Professor Marian Pauchnik, in his more recent writings, stated that law as a system is the totality of effective legal principles and legal rules. The emphasis here again is on effective legal principles and legal rules, because unfortunately many rules and principles also of the European Union are not really effective, and I will be touching upon some of them. Gregory Schaffer, another legal philosopher, stated that law cannot be adequately understood outside of empirical study. What does it mean? You have to look how the law works and functions in the real world. Now, European Union, and also even more so, the European law, I would say, is a work in progress. If you look into Article 1, second paragraph of the Treaty of Lisbon, you will find that the treaty itself states that it marks a new stage in the process of creating an ever closer union among the peoples of Europe. Meaning it is just one stage, and this ever closer union statement, which is, so to say, aimed at, has quite far-reaching implications and causes already quite challenging situations. Now, the other point of this work in progress is that the progress is vastly dependent on unanimous decisions of the member states. And as it is well known, they are more often than not quite at odds. So there is a quasi-inbuilt break in this development and the progressive creation of a closer union. Therefore, I fully agree, after I have studied a little bit more closely the primary and also to a certain extent the secondary law of the EU, that Gunnar Beck is correct in his observation that EU primary law is characterized by a high degree of vagueness and pervasive norm collision across most of its substantive areas. What does it mean for the lawyers, and especially for judges, but also attorneys general, as Professor Trstenjak used to be for some time? That means a lot of work for those interpreting and even more so applying that rules and principles. Now, what about the Court of Justice? I'm, of course, a little bit hesitant, and I should be prudent in front of Professor Trstenjak to talk about the Court of Justice. But one has to understand that under the primary law, it is the guardian of the effectiveness and primacy of the EU law. It is staffed by judges and attorneys general from all member states. There are not so many attorneys general, but nevertheless, they come from all member states. The court as a whole, and this is a specialty, I would say it's the unique institution of the European Union, which decides by majority of votes, no matter what composition, Grand Chamber, 5 judges, 3 judges, and there are no dissenting opinions. And there is no difference between the votes of judges, be from a small or a big member state. Also something, if you compare that with the situation in the European Council, in the Council, or in the Parliament, this is quite a unique institution. And as such, has played a very, very important role, not only in interpreting the law, but also in further developing not even only the law, but even the unity of the European Union, or the community as it was called before. The member states, and that is a problem for some member states now, are obliged to provide remedies to effectively enforce the rulings of the court. That is enshrined in Article 19, first paragraph, first subparagraph, not literally as is stated here, but as the substance. The court has no jurisdiction with respect to EU's common foreign and security policy, apart from, let's say, some monitoring of compliance with procedural rules. How important the court is for the functioning of the Europe is best demonstrated in the so-called 17th Declaration concerning primacy, which is annexed to the final act of the Lisbon Conference. The conference recalled literally, in accordance with the well-settled case law of the Court of Justice of the European Union, the treaties and the law adopted by the Union on the basis of the treaties have primacy over the law of member states. And in addition to that, under the conditions laid down by actually the court. Now, if you look into the treaties, you will not find anything about the primacy of the law, because the member states were somehow not able to agree on that. But on the other hand, the Court of Justice, by its case law, has really established the primacy of the EU law over the law of the member states, with some implications, as you know right now. Now, judging and applying the primary law of the European Union by the court has, of course, a number of challenging implications. On the one hand, it has, of course, always to observe the core values which are set forth in Article 2, meaning respect, human dignity, freedom, democracy, equality. The rule of law is here in red only because it plays right now quite a special role, and I'm aware that Professor Trstenjak will be talking more on that, and really in a competent way. The court must also take into account the limits of the union competences, because the union has only the competences which were conferred upon it by the member states. And those competences, again, are limited by the principles of subsidiarity and proportionality, because the union can use it only within these limits. To go a step further, in addition to that, the union, meaning also when interpreting the union's law, the equality of member states before the treaties, their national identities, which are inherent, and so forth and so forth. So it is a very, very complex building of law. And in the end, in particular, which is quite important at the present time, national security remains the sole responsibility of each member state. Now, going back to the current challenges. I used already in my abstract, let's say, a few sentences from The Economist, and I must say The Economist never has, they never indicate the author of the article or contribution, so therefore it's always only The Economist. They pointed last year that at present the union is facing challenges on fiscal policy, on foreign policy, on defense and migration. And these all challenges cut to the heart of sovereignty. Now, I will spend a few words about the sovereignty. That the dreams, I would say, the idea of the EU to become a global player requires a strategic unity, which is not easy to find between the 27-member bloc. And most, for the lawyers at least, is the fact that all the attempts to turn the EU into an advocate of liberal democratic values fail to inspire everyone. So it's not difficult to identify who is not particularly inspired by that attempt. In the past, correctly observed, those such disagreements on direction could be settled by standing still, one of the approaches of our departing Chancellor Angela Merkel. Today, the forces that held the EU together risk pulling it apart. I would say, and as you will hear, even the fact that the very competent case law of the Court of Justice may have some such consequences. Now, coming to one of those challenges, I will not spend much time to talk about Poland as an example, but the fact is that the Republic of Poland, as it also the case with the Republic of Hungary, has disregarded a number of judgments of the Court of Europe of European Union, especially also one of the November of 2019. The consequence of this disregard was were orders issued by the Vice President of the CJEU, which have been also disregarded. In the end, very recently, as you know, the Vice President ordered the Republic of Poland to pay quite a remarkable sum as a periodic payment, namely €1 million per day, as long as they do not, let's say, obey the orders. Now, the peak of this entire challenge, which now comes from Poland, is the decision of the Polish Constitutional Tribunal of October 7. I will not go into details, but just summarize that according to this decision, a number of provisions of the Treaty of Lisbon is actually inconsistent with some provisions of the Constitution of the Republic of Poland, and that the Constitution of Republic of Poland prevails. So it's really something much more than what economists 2 years ago actually deplored. Now, the question is, what can the EU actually do? Is EU adequately armed to react? And this is not only linked now to the question of the Polish decision of the Constitutional Tribunal, but it is a general one. Commission's President von der Leyen, in her emotional speech in the European Parliament, said, well, we have 3 options: legally challenge the judgment, meaning going again to the Court of Justice, or use conditionality mechanisms and other financial tools, meaning not releasing money, which Poland could claim actually, or trigger the complex and complicated mechanism of Article 7 of the treaty, meaning first to establish whether there is a serious risk of a breach of those values or whether such breach already exists. In the end, then achieve that some voting rights or other consequences could follow. Now, Angela Merkel, in her more moderate way, immediately reacted and said, oh, you can't actually resolve big political differences through court cases. We should continue with the dialogue. That was not by all well received. And the fact is that Mr. Kaczynski, the peace leader, is nevertheless intensifying the conflict and ignoring the fines, and that the government shows no sign of relenting in its attack on judges who defend judicial independence, be that, of course, Polish judges, which initiated one of those proceedings in the Court of Justice, or the Court of Justice itself. Now, I mentioned in my abstract that what is very important and seemingly, let's say, ignored are the so-called unknown knowns. This unknown knowns as a term goes back to the late Secretary of Defense of the United States, Rumsfeld, but in the end was interpreted by a sociologist from the United States that unknown knowns are things which we know, but which we do not want to admit them because this is an uncomfortable knowledge. And I think the politics cannot ignore, and also the lawyers cannot, let's say, continually ignore the so-called uncomfortable knowledge. And what about Brexit and Polexit as regards the unknown knowns? From The Economist, one can learn that Britain had supported the eastward expansion of the EU, meaning inclusion of Poland and other member states from the Eastern Europe, because they had the idea that a larger Europe seemed like an alternative to the deeper one. So they didn't like the idea of ever closer union. Of course, they miscalculated because within 1 year, they had an immigration from Poland and Romania of up, I think, nearly 900,000, which in the end had a role to play in the Brexit. Now, The Economist recently, October 16, wrote that the problem in case of Poland is not that Poland is trying to leave the EU, but the problem is that it intends to stay. Although Polish Constitutional Court trumped the fundamental parts of EU law. That part is such as ever closer union. Now, David Cameron, this is all unknown knowledge, unknown knowns. David Cameron, before the referendum on Brexit had taken place, asked and begged the Commission for the concession, for a number of concessions, among others also to be allowed to include an opt-out from ever closer union. So the idea was stay in the union, but have the opportunity not to participate in this work in progress towards an ever closer union. As we know, that did not happen. Now, according to this, let's say, interesting expression of The Economist, Poland simply threw the fryer without warning. And everybody has to duck down in order not to be heated, but nobody knows actually how to get out of this situation. So this is one example for the unknown knowns. If we take the challenge of the migrants at the Belarus-Polish border, which stands, of course, for the migrants in Greece, in Spain, in Italy, but in a more visible way now, all of a sudden, one has to recall that EU has adopted since 2006, when it established the so-called Frontex, a number of regulations, which should actually provide a better defense security on the external borders of the Union. However, the responsibility for the control and surveillance of external border remained with the member states. And the repeated magic spirit of shared responsibility, I say magic, because it doesn't really work, never really materialized. The tensions between member states and the EU Frontex remained. And if you look now to Poland, Poland asked on the one hand EU for financial support to build up a border wall, did not, to my knowledge, get one, but at the same time did not ask Frontex to engage in this affair at all. Now, let me spend a few minutes with the issue of EU and member states' sovereignty. If we go back far back to the 16th century, to the famous book of Jean Baudin on 6 livres de la République, one can read that sovereignty is an absolute and perpetual power vested in a commonwealth. It cannot in any way be subject to the commands of another. And Thomas Hobbes, some 100 years later, stated that sovereignty is the artificial soul of Leviathan, meaning the state, which was created for its protection and defense. Now, is EU sovereign in this sense? And what about the member states? A look at Article 42 of the Treaty of Lisbon may give you an answer. The security and defense policy is an integral part of common foreign and security policy. And what is that policy? Is including a progressive forming of a common union defense policy leading to a common defense. So at present, we are working already on a common defense policy, but Europe is far away, that's in the clouds. Whenever, if at all, there will be a common defense. And in addition to that, EU has to take care, inter alia, has to respect the obligations of member states entered into under the NATO treaty. So apart from Austria, Cyprus, Finland, Ireland, Malta, and Sweden, all members of the EU, also Slovenia, are NATO members, and they entered under the NATO treaty into a number of obligations, think only about Article 5. I have no time to elaborate that on. Now, another unknown known, which is of an importance when we think about the unilateral withdrawal from Afghanistan by the United States, or the conclusion of the so-called AUKUS Pact, meaning Australia, United Kingdom, and US, without consulting or even informing the NATO members. I recall, and I know that I'm using time, but I think it's quite important to learn also for Poland and the Baltic states and the others, that in 1943 there was a Tehran conference in which Roosevelt, Churchill, and Stalin participated. And Churchill asked Roosevelt, please consult with me before meeting Stalin, which Roosevelt refused. The outcome of that conference was, by and large, that Soviet Union was considered a kind of a rule over the Eastern Europe. Now, when Churchill came back, he wrote, when I was at Tehran, I realized for the first time what a small country Great Britain is. On the one hand, the big Russian bear, on the other hand, the great American elephant, and in between them, the poor little English donkey, at that time still an empire, already a declining one, who is the only one to know the right way home. Now, if we transfer this to today's day, Europe seems to me maybe not a donkey, but a mule, and not in between Russian bear only and American elephant. That company has been joined by a Chinese panda. Now, another thing which also has to be recalled. In 1959, President de Gaulle thanked the US President Eisenhower. I will not go into detail why they met, and thanks the United States for the help it had received from the United States during the World War I and II. But he added and recalled that the help arrived both times when France was already devastated. So the question is it such a good idea to rely on own security on third parties or an organization over which one has no control? Now, to come closer to the end, to my understanding, the most challenging issue for the lawyers is the application and interpretation of the EU law due to its high degree of vagueness and pervasive norm collision, which just reflect the political compromise behind those norms. The court, whenever it was confronted with this reality in interpreting and applying the law, placed every provision in its context and interpreted it in the light of EU law as a whole, and has considered the objective truth thereof and the state of evolution at the date of the decision. Now, in other words, the court has fixed things in line with the overall objectives of the EU law, which the legislator, absent consensus, unanimity, or maybe the necessary knowledge, could not. So what happened now, the more heterogeneous and large EU, for this, the EU driving approach of the court faces, to my understanding, increasing scrutiny, a potential cause of serious frictions for which EU is neither politically nor legally adequately armed. So what is necessary are common efforts of politicians and lawyers to find a way out of this threatening blind alley. This is overdue, because even positive results of political talks alone will not suffice in the long run. We need secured and clear and enforceable legal rules. My last comment. To avoid the threatening EU catharsis, politicians and lawyers must work together. Politicians must finally resist the temptation to implement or maintain in EU laws unmeetable demand for ethical rationality. Unmeetable means that you cannot fulfill them, such as, for instance, very briefly, the member states are responsible for security of the external EU borders. They have to respect the rights for asylum of intruding immigrants. They have thousands of problems, if at all possible, to return them to their countries. At the same time, they are blamed for, especially by member states without external borders, to violate core EU values, international law, etc. So, politicians and lawyers of the EU and also of the member states must, without closing their eyes before the unknown knowns, they cannot ignore things they know and which are just uncomfortable. And they have to provide for effective, workable solutions in the EU law to meet these challenges before it is too late. And it is already very late. Da zaključim, hvala za pozornost in tudi za potrpežljivost, da ste me poslušali v angleščini.
Hvala lepa, cenjeni profesor Štravs. Zanimivo razmišljanje, zdaj ni se toliko, pardon, mislim, da se mi kamera nekaj ne vključi, toliko konkretno nanašalo sicer na probleme v Sloveniji, ampak evropski problemi so tudi slovenski problemi, tako da bomo poskušali to povezati. Jaz sem sicer napisala udeležencem, če so kakšno vprašanje, naj napišejo v chat, vendar zaenkrat ni nobenih vprašanj, mogoče pa, če boste se nam pridružili še pri naslednji sekciji, ne vem, kakšen so vaši plani, mogoče bi tam se še kaj vključite v razpravo. Jaz mislim nekaj tudi povedati, kar se mi vedno postavlja vprašanje, zdaj je to v zvezi s Poljsko in vse ti postopki, kakšni relaciji vidite vi kot nemški pravnik, to ves čas problem evropskega prava v Nemčiji v zvezi s teorijo Solange in ta problem nemškega ustavnega sodišča, ki je bil toliko let in še vedno sedaj komisija ponovno grozi s tožbo. Tako da bi bil mogoče tudi tukaj zapotegniti kakšne paralele, mogoče lahko tudi sedaj, če imate dva stavka, ali pa če boste potem še v sekciji lahko tudi naknadno.
Kot sem rekel, jaz nisem specialist na tem področju evropskega prava, ampak seveda odločbe nemškega ustavnega sodišča niso primerljive, popolnoma primerljive s tem, kar se je zdaj zgodilo na Poljskem. So pa tudi signal, ki ga je treba samo upoštevati. Se pravi, Evropska unija na koncu koncev in članice morajo razumeti, da je treba najti kompromise, ki delujejo, in ne nekaj, kar potem postane sicer črka na papirju, ki se jo pa ne da izpolniti. To sem hotel samo poudariti, ne bi se hotel spuščati v podrobnosti teorij, ki ste jih omenila, ker konec koncev ne vodijo do cilja, ki ga bi morala Unija in ki bi ga morale države članice imeti na vidu ves čas, predno je prepozno, ker še več, če se tega kumulira, bolj težko bo. Jaz bom pa poslušal še nekaj časa prispevke drugih. Hvala.
Dobro, hvala lepa. S tem je ta uvodni del končan.